Assalamualaikum and hi. We are from Group 7 and we'll be presenting case analysis for Law 083. Hi, I'm going to explain an introduction of this case, CHU tak FAI against Public Prosecutor. It is a criminal appeal case that was held in Federal Court of Putrajaya and was decided on 20 August 2001.
CHU tak FAI, a Hong Kong resident who was the applicant of this case, was found to be carrying 17 packages of heroin weighing 2,125.4 grams and consequently charged under Section 39B Clause 1 Subsection A of the Dangerous Drugs Act 1952 and punishable under Section 39B Clause 2 of the Act. The applicant was convicted and sentenced to death by the High Court. However, he was dissatisfied with the decision. Thus, the applicant appealed to the Court of Appeal but has been dismissed. The applicant made an application under Rules 137 of Rules of the Federal Court 1995 to set aside his conviction and sentence to death to the Federal Court. However, the appeal was dismissed. There are three legal issues that arise in this case. The first one would be whether the Federal Court had jurisdiction to hear the application under Rules 157 or to reopen and review the case on its merit when the case had been conclusively settled by the court. Second, whether there is lack of fairness or justice in the evidence of chemists may cause abuse of process in the court. And third, whether evidence of the chemist is defect. These are the relevant laws of this case. Section 39B, Clause 1, Subsection A of the Dangerous Drugs Act 1952. Under this provision, no person shall on his own behalf or on behalf of any person, whether or not such person is in Malaysia, traffic in a dangerous drug in which CHU tak FAI traffic heroin into Malaysia. The second provision is Section 39B, Clause 2 of the Dangerous Drugs Act 1952, where under this provision, drug trafficking may be punishable by death, and it's the main offense for which death sentences are handed out in Malaysia at that period of time in 2006. And the third provision is Rule 137 of Rules of the Federal Court 1955, where Federal Court, being the apex court of the country, is not bound by its own decision. In hearing such an appeal, the Federal Court may depart from its earlier decisions. So in this context, Rule 137 of the Rules of the Federal Court 1995 enables the Federal Court in upholding justice to review its own decisions in exceptional cases.
Decision of the Court. The principles governing the jurisdiction and exercise of the power of review by the Federal Court is well settled. The Federal Court, as the apex court, does have the jurisdiction and power to hear and review any matter brought before the court under R127, which is Rules of Jurisdiction, provided that such an exercise can only be undertaken sparingly and only in rare and exceptional circumstances where there is no alternative remedy available to prevent an injustice or to prevent an abuse of the process of the court. Secondly, the evidence of the chemist was not defective. The presumption in Section 37 subsection J of the Act was inapplicable. The chemist had analyzed all the 17 packages in which the chemist had used 100% or the whole quantity of the whitish substances handed to him, and thereby making it unnecessary for the chemist and the prosecution to rely on Section 37 subsection J of the Act. Next, the court was entitled to accept the evidence of the chemist on its face value without the necessity for him to go into details of what he did in the laboratory step by step, unless the evidence is so inherently incredible that no reasonable person can believe it to be true, or the defense calls evidence in rebuttal by another expert. Furthermore, there was no requirement for the amount or the weight of the samples of the drug to be taken for the purpose of analysis by the chemist. It is up to the chemist to carry out the analysis scientifically. It is also for the chemist to determine the adequacy of samples for the purpose of analysis. And last but not least, there was no lack of fairness or justice in the evidence of the chemist. It was not the kind of case where this court should invoke its inherent power under R137. There was absolutely no injustice caused to the applicant, nor was there any abuse of the process of the court in the conviction and sentence of the applicant. The Federal Court does have the jurisdiction to hear and review any matter brought up before the court under R127. However, there was no injustice or lack of fairness done by the chemist. Therefore, there was not the kind of case where the court should invoke its inherent power under R137. Second, the evidence of the chemist is also not effective as he had tested all the YT substance in each of the 17 packages, as he did not rely on section 37 subsection J of the Act, in which could cause unfairness and injustice on the applicant's conviction and sentence. In this case, the provision section 37 subsection J does not apply due to the fact that the chemist tested 100% of the YT substances from each 17 packages instead of just 10% that is stated in the provision. Therefore, it is unnecessary for the chemist and the prosecution to rely on section 37 subsection J.